Hello everyone, welcome to Naandhi. Myself Shivakumar, and in this video we will discuss everything about sedition. In the recent times, there has been an increase in the instances in which sedition charges were pressed against intellectuals, human rights activists, filmmakers, university teachers, students, and journalists. The law has been in controversy for far too long. Often the central and state governments are criticized for using the law, section 124A of the Indian Penal Code IPC, against vocal critics of their policies. From jail student leader Kanaya Kumar to writer Arundhati Rai, Hardik Patel to the most recent case Disha Ravi. They're all booked under sedition. And this news clip is related to the Hindu newspaper, which is saying that journalists need protection against sedition charges. SC quashes case against Vinod Dua. Who is this Vinod Dua? Vinod Dua is a Padma Shri awardee and a senior journalist. Recently, in his show, he spoke against central government for handling the COVID situation. So Himachal Pradesh government charged him under Sedition Act for criticizing Narendra Modi. But Supreme Court quashed a case against Vinod Dua, referring to 1962 Kedarnath Singh verdict, saying that mere commenting or mere criticism against government is not sedition. It also said that the time is long past when mere criticism of government was sufficient to constitute sedition. It was referring to the times of Britishers when mere criticism against the British government constituted as a sedition. Now we are living in a democratic country, and right to free speech and expression is a crucial component of democracy. So dissent is the backbone of democracy. So mere criticism or commenting or mere sloganeering against a government is not a sedition. Then let's see what is sedition and what constitutes sedition. Section 124A of Indian Penal Code, which deals with sedition, it's not only defines what constitutes sedition, but also it clearly mentions about punishment for sedition. Let's see first what constitutes sedition. Whoever words, either spoken or written or by signs or by visible representation or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India constitutes sedition. It's simple. Let me put it in a simple way. If any person by speeches or writing in social media platforms, whether it's Facebook, Twitter, WhatsApp, or writing in newspapers or through movies, paintings, or cartoons, tries to promote enmity or hatred against the government or tries to subvert the government through violent means is constitutes sedition. Just mere sloganeering or just writing or commenting, just criticizing against the government is not a sedition until it promotes hatred or disloyalty or enmity against or towards the government established by law. Then only it constitutes as sedition. And what is the punishment for acts of sedition? It clearly mentioned that imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added or punished with fine, right? So, and one more thing we need to remember, it is a non-bailable offense, and imprisonment up to 3 years to a lifetime, to which fine may be added, and a person charged under this law barred from government job, and they have to leave without their passport and must produce themselves in court at all times as and when required. One more thing we need to remember, however, comments without exciting or attempts to excite hatred, contempt or disaffection, which includes disloyalty and all kinds of enmity, will not constitute an offense under this section. And section 124A forms part of chapter 6 of IPC, which deals with offenses against the state. So when it comes to the origin of sedition law in modern India, it was originally drafted in 1837 by Thomas Macaulay, a British historian and politician, but was inexplicably omitted when IPC was enacted in 1860. As you know that it replaced Mohammedan law. Before IPC was introduced in India in 1860, we had Mohammedan law, right? So section 124A was inserted in 1870 by an amendment introduced by Sir James Stephen. Why sedition? The origin of sedition law in India is linked to Wahhabi movement. This is very important for your preliminary point of view. Wahhabi movement is basically a Islam revivalist socio-religious movement. During the times of 1830s to 1870s. Initially, it was a revivalist movement, Islam revivalist movement, but after 1857, Wahhabi movement became a militant movement against the suppression of British rule. So Britishers, in order to suppress the increasing Wahhabi movement activities, the Raj introduced this section under the title Exciting Disaffection. As I told you, this disaffection also includes disloyalty or promoting all kinds of enmity against the British Raj. So in order to suppress the activities and voice of the Wahhabi movement, or in order to stifle any voice of dissent against the British rule in India and suppress the activities in favor of national independence, and to convict and sentence freedom fighters, Britishers introduced sedition in 1870, a decade after IPC was introduced into India. Let's see some of the famous cases related to sedition in India. So during the pre-independence period, this sedition was used against freedom fighters to suppress the dissent or to suppress the voice against British rule. Right? The first one, and one of the first cases, Queen Empress versus Jogendra Chandra Bose, 1891. Jogendra Chandra Bose, the editor of newspaper Bango Basi, wrote an article criticizing the Age of Consent Act 1891. So his criticism was taken as a disobedience towards the government. So therefore he was booked under sedition, and however later the case was dropped after he was released on bail. One of the most famous and controversial pre-independence sedition trials is related to Lokamanya Balagangadhar Tilak. Balagangadhar Tilak, who has given an electrifying slogan that is Swaraj is my birthright and I shall have it, was himself convicted thrice for sedition charges. Once in 1897 for preaching disaffection against British Raj. So he was sentenced to 18 months in prison. In 1919, Tilak was charged under sedition for defending Prafulla Chaki and Khudiram Bose, who were responsible for Muzaffarpur conspiracy case in his paper Kesari. And he also called for immediate Swaraj and self-rule from British rule. And in 1916, when for third time Tilak was charged for sedition over his lecture on self-rule. And one thing which is very important to remember here is that during his two sedition trials, that is 1909 and 1916, the lawyer who appeared in defense of Balagangadhar Tilak is none other than Muhammad Ali Jinnah. You must remember this name, which is very important for your preliminary point of view. And at the same time, in 1919, when Tilak was convicted under sedition law, he was punished with 6-year jail sentence, and he served this jail sentence in Mandalay jail of Burma, which is current Myanmar, and also they imposed a fine of 1,000 rupees. So recently, Indian government unveiled a bust of Balagangadhar Tilak at Mandalay jail in Myanmar in order to promote soft power, in order to commemorate the 100th centenary celebrations of Balagangadhar Tilak. And one more most important sedition trials is related to Mahatma Gandhi, the father of India. Mahatma Gandhi was imprisoned for six years for his articles in his newspaper Young India. He was charged along with Shankarlal Banker, the proprietor of Young India, for publishing 3 articles in 1922. So the charges imposed on him were bringing or attempts to excite disaffection towards British government. So Mahatma Gandhi termed section 124A as prince among the political sections of Indian Penal Code designed to suppress liberty of the citizens. So it's a very, very important statement given by Mahatma Gandhi ji against section 124. So we must remember this. After independence, Constituent Assembly was constituted to frame a constitution for Indians. So a committee on fundamental rights headed by Sardar Vallabhbhai Patel was included fundamental rights in the Indian Constitution. So they have also ensured right to speech and expression under Article 19(1)(a). But they've also included Article 19(2), which restricts Article 19(1)(a). Unfortunately, here one thing should be remembered, important to remember, that is, in this Article 19(2), which is a restriction to right to speech and expression, they have included sedition. This is really unfortunate. This is very important. That means they have included sedition in the draft constitution. Okay, but finally, because of the opposition from the fellow Constituent Assembly members, the word sedition was finally dropped from the final draft of the Constitution. So although the term sedition vanished constitutionally, but it remained under IPC as a section 124A. However, sedition laws remained on the statute books post-independence and were used repeatedly by both central government and state governments to stifle political dissent. Here, one thing is need to be remembered: sedition law can be used by central governments and state governments also. Okay, so section 124A has been challenged in various courts in specific cases since it goes against article 119(1)A, which guarantees free speech and expression under fundamental rights. So some of the famous judgments are Bhushan and another versus State of Delhi 1950 and Ramesh Thapa versus State of Madras 1950. So in this particular case, the apex court held that a law which restricted speech on the ground that it would disturb public order was unconstitutional. So thus these decisions prompted Constitution First Amendment Act 1951, where Article 19(2) was rewritten to replace undermining the security of the state with in the interest of public order and relations with friendly states. Here, two things need to be remembered. After this judgment, through Constitution First Amendment Act 1951, they have expanded the scope of 19(2) by including in the interest of public order and relations with friendly state. That means they have expanded the scope of restrictions against Article 19(1)A. And at the same time, one progressive thing also has been done by this amendment, that is, they've also inserted the word reasonable before restrictions. So earlier there were only restrictions, but now they've added reasonable restrictions, which was meant to provide a safeguard against misuse by the government. This is very, very important. Who will decide whether these particular restrictions are reasonable or not? So therefore, by including this reasonable, they have given a scope for judicial review. The court has to decide whether the restrictions imposed by central or state government or the sedition charges imposed by these governments against the fundamental right to speech and expression are reasonable or not. So this particular amendment is very, very important for your examination point of view. There is one more important case, that is Ramanandan versus State of UP 1958. Ramanandan was charged under sedition for criticizing Congress government for not being able to address extreme poverty in the state of UP and exhorted cultivators and laborers to form an army and overthrow the government if needed. He also accused the then Prime Minister Nehru of being a traitor for dividing the country into two. So even in this case, the Supreme Court, the court overturned Ramanandan's conviction and declared section 124A to be unconstitutional. So just mere criticism or commenting against the government or the Prime Minister is not a sedition, and it is unconstitutional to book under sedition. Kedarnath Singh versus State of Bihar 1962. This particular judgment is very important. So this case involved Kedarnath, a member of Forward Communist Party in Bihar, who accused the then Congress government for corruption, black marketing and tyranny, and also targeted Vinoba Bhave's attempts to redistribute land. So for that, he was booked under section 124A, and sentenced to 1 year imprisonment. So then he approached Supreme Court. So the Supreme Court judgment was very interesting here. So the Supreme Court upheld the constitutionality of the sedition law, but at the same time curtailing its meaning, limiting its application to acts involving intention or tendency to create disorder, disturbance of law and order, or inciting to violence. That means until and unless any speech or slogan or which results to public disorder or disturbance of law and order, or which unless incites violence, is not a sedition. That means mere criticism or commenting on the government is not a sedition. So individual has a right to express his opinion, has a right to express his idea without inciting violence, without disturbing law and order, or without creating public disorder in the society. So it's not a sedition. So even in the Balwant Singh versus State of Punjab, the Supreme Court has clearly indicated that unless there is public disorder, merely sloganeering can't attract punishment under section 124A. So even Shreya Singh versus Union of India, which is very important, the recent one, the court clearly indicated that an individual can advocate and propagate an idea without inciting violence, or without creating a public disorder, or without disturbing law and order. So it's not a sedition. Arguments in support of section 124A. This section, sedition, was also included in the draft constitution. We have discussed that. So there were certain reasons, because of certain reasons, the framers of Indian constitution decided to include sedition, or decided to continue sedition under article 19(2) as a restriction to 19(1)(a), that is free speech and expression, because of certain reasons. What are they? In order to combat anti-national, secessionist or terrorist elements, in order to protect the elected government from attempts to overthrow the government with violent and illegal means, in order to tackle Maoist insurgency and rebel groups. This sedition was supported by some of the members of Constituent Assembly on these grounds. The abolition of section, so against this backdrop, the abolition of section 124A would be ill-advised, mainly because it has been wrongly invoked in some highly publicized cases. So according to one section of arguments, right, one group of people who supports the sedition, so this abolition or repeal of sedition is ill-advised because of these reasons. So let's see why sedition law should be repealed. Section 124A is a relic of colonial legacy and unsuited in democracy, because in the democracy it guarantees free speech and expression, and being the largest democracy in the world, in India, dissent is the fundamental right. Okay, so it is unsuitable for the modern democratic values and principles. That's why it should be repealed. And one more important thing is that the British, who introduced sedition to oppress Indians, have themselves abolished the law in their country. There is no reason why should not India abolish this. And right to question, criticize and change rulers is a fundamental to the idea of democracy also. Mainly criminalizing dissent is completely undemocratic. And the term used under section 124A, like disaffection or vague and subject to different interpretations to the whims and fancies of the investigation officers. Sedition leads to sort of unauthorized censorship, for it produces a chilling effect on free speech also. And one more important thing in support of repealing the sedition, in 1979, India ratified the International Covenant on Civil and Political Rights, ICCPR, which sets forth internationally recognized standards for the protection of freedom of expression. However, misuse of sedition and arbitrary slapping of charges are inconsistent with India's international commitments. Moreover, IPC and Unlawful Activities Prevention Act have provisions that penalize disrupting the public order or overthrowing the government with violence with illegal means. These are sufficient for protecting the national integrity. There is no need for Section 124A. The sedition law is being misused as a tool to persecute political dissent. A wide and concentrated executive discretion is inbuilt into in which permits the blatant abuse. So because of all these arguments, it was suggested that the sedition law must be scrapped. Disutility or misuse of sedition law. Between 2016-2019, according to the National Crimes Record Bureau, the number of cases filed under Section 124A, Sedition of Indian Penal Code, increased by 160%, while the rate of conviction dropped to 3.3% in 2019. So out of 96 suspects arrested under charges of sedition in 1929, only 2 persons have been convicted. That means 94 persons were arrested arbitrarily. It shows how the sedition law has been misused to suppress the voice or criticism against the government. And if you see the age profile of those arrested, mostly belongs to 18 to 30 age group, and states Karnataka had recorded the maximum number of sedition cases in 2019 with 22, followed by Assam, Jammu and Kashmir, Uttar Pradesh. These are the top states for sedition charges. Let's see what is the viewpoint of Law Commission of India. Law Commission of India, which is the center's topmost advisory body on laws. In 2018, it recommended that it is time to rethink or even repeal the provisions of sedition section 124A from the Indian Penal Code. It suggested to rethink or repeal the provisions of sedition. And some of the significant observations by the Law Commission report of 2018 are: why should India retain sedition when the British, who introduced sedition to oppress Indians, have themselves abolished the law in their country? The Commission asked. It's one of the major questions asked by Law Commission, and it also observed that for merely expressing a thought that is not in consonance with the policy of the government of the day, a person should not be charged under section. If the country is not open to positive criticism, there lies little difference between pre and post independence eras. Right to criticize one's own history and the right to offend are rights protected under free speech. While it is essential to protect national integrity, it should not be misused as a tool to curb free speech. So this is the statement was given by the Law Commission of India in its 2018 report. If you look at the sedition laws around the world, in USA it's almost a dead law. In UK it's abolished in 2009. In New Zealand, it's abolished in 2007. When the major countries in the world abolished this draconian law, why can't the largest democracy of the world would scrap or abolish this sedition law? So this is the major argument against the misuse and against the section 124A of IPC. Let me conclude. India is the largest democracy of the world, and the right to free speech and expression is an essential ingredient of democracy. The expression or thought that is not in consonance with the policy of the government of the day should not be considered as sedition. The Law Commission has rightly said, an expression of frustration over the state of affairs cannot be treated as sedition. If the country is not open to positive criticism, there would be no difference between the pre and post-independence eras.